Welcome to the Module 9 presentation. In this lecture, we will be talking about, first of all, the chronology of a trial in general, then some basic rules on the examination of witnesses, then the issue of cross-examination, leading questions, hostile witnesses, prior consistent statements, and impeachment of witnesses. First, very briefly, the basic stages of a trial are, number one, the plaintiff's main case or case in chief, then the defendant's case in chief or evidence for the defense, the plaintiff's evidence in rebuttal, and the defendant's evidence in rejoinder or rebuttal. In each stage, each witness's examination may pass through these steps: direct examination conducted by the party who calls a witness, cross-examination by the adversary, and redirect and recross. The concept of rebuttal testimony is very limited. This falls within the realm of the plaintiff, but only after the defendant has presented a case. And when I use the term plaintiff here, I also mean prosecution in a criminal trial. The scope of rebuttal testimony is extremely limited. It can only directly address and respond to any evidence that the defendant has presented in their case in chief. It cannot bring in new evidence that should have been brought in stage one, the case in chief. So once again, it's very limited. And if a defendant rests their case without presenting evidence, then there is no rebuttal, obviously, because there's nothing to rebut. In return, the defendant has an opportunity to present what's called rejoinder or sur-rebuttal. It's the same concept, just different terms for it. That, again, is even further limited to the scope of evidence that the plaintiff or has presented in rebuttal. So as you can see, from the plaintiff's main case and the defendant's case in chief, we start to narrow the focus and the scope of evidence that's going to be considered to be admissible and relevant. And throughout all, the trial judge is going to control these stages of presentation to make certain that the case proceeds in an orderly fashion. Again, each witness for either the plaintiff, prosecution, or the defense will, at the very least, undergo direct examination conducted by the party who calls out witnesses, and most probably cross-examination by the adversary or the party opposing that witness's testimony. Then, again, redirect and recross examination takes place, as I've just said. The examination of witnesses raises a host of issues. Number one, the extent of judicial control of the trial, and this is going to be essentially governed by the rules of evidence. Two, the proper methods of eliciting testimony on direct examination. How far, for example, can the plaintiff or the prosecution go in questioning their witnesses and in presenting evidence at that stage of the trial in the case in chief? Three, the scope of cross-examination, and again, the trial court is going to be looking at this to limit the scope of cross-examination to the issues that were discussed on direct examination. And other than in rare instances, anything beyond that direct testimony will be beyond the scope of cross-examination. For the purpose of redirect and recross examination, the trial court will analyze the scope of the and the direction of these presentations, and we'll decide virtually question by question whether it's appropriate for redirect and recross examination. The court will also strictly control the use of leading questions, especially when a party is calling witnesses in their own case in chief. And this applies both to a plaintiff prosecutor as well as a defendant. There are many other issues, such as a refreshing recollection and the privilege against self-incrimination and the right of confrontation, all of which the trial court will have a direct hand in deciding the admissibility and the approach to be taken in presenting this type of evidence. And the basic privilege against self-incrimination, the right of confrontation, we'll discuss later. And the quote that I just read you is from Section 2001 from the textbook Understanding Evidence, second edition by Paul Gianelli, and it's published by LexisNexis Matthew Bender, and it's a 2006 publication. I point this out that this text is available readily online at any of the online booksellers, the major booksellers anyhow, and it's relatively inexpensive, depending upon whether you get a used version, which is quite acceptable, or a new version. The price will be somewhere between $15 to $20 to $22. If you really want to delve into the subject of evidence and the rules of evidence, I'd suggest you go ahead and purchase this particular text because it's very good, it's very straightforward, and it's written in understandable terms that a layperson can understand. Okay, again, I have no interest, financial or otherwise, in the sale of this text. So that's my financial disclaimer here. Under Federal Rule 611, which addresses the mode and order of examining witnesses and presenting evidence, paragraph A states control by the court and the purposes. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to 1. Make those procedures effective for determining the truth, 2. Avoid wasting time, and 3. Protect witnesses from harassment or undue embarrassment. And that's the first paragraph of 3 subparagraphs in FRE 611. The advisory committee, who worked towards the compilation of the federal rules, also made some commentary, and I have that here for you to see because it's a simple explanation of what they were attempting to achieve. Subdivision A, which addresses the paragraph I just read you in the rule, the comment says spelling out detailed rules to govern the mode and order of interrogating witnesses presenting evidence is neither desirable nor feasible. The ultimate responsibility for the effective working of the adversary system rests with a judge, where it properly belongs. The rule sets forth the objectives which he should seek to attain. Item 1 in subparagraph A restates in broad terms the power and obligation of the judge as developed under common law principles. It covers such concerns as whether testimony shall be in the form of a free narrative, for example, or responses to specific questions, and also the order of calling witnesses and presenting evidence. He also supervises the use of demonstrative evidence and its production, and we'll be talking about what that is in a later module, and many other questions arising during the course of a trial which can be solved only by the judge's common sense and fairness in view of the particular circumstances, and always, of course, applying the appropriate law to the situation. Item 2 in paragraph A is addressed to avoid the avoidance of needless consumption of time, a matter of daily concern in the disposition of cases. A companion piece is found in the discretion vested in the judge to exclude evidence as a waste of time in Rule 403. And FRE 403 we will discuss in another module. Item 3 in Subdivision A calls for a judgment under the particular circumstances as to whether interrogation tactics entail harassment or undue embarrassment. Pertinent circumstances include the importance of the testimony, the nature of the inquiry, its relevance to credibility, waste of time and confusion, while the trial judge should protect the witness from questions which go beyond the bounds of proper cross-examination merely to harass, annoy, or humiliate. This protection is by no means forecloses any efforts to discredit the witness that are lawful and appropriate. Paragraph B of FRE 611 states, cross-examination should not go beyond the subject matter of the direct examination and matters affecting the witness's credibility. The court may allow inquiry into additional matters as if on direct examination, which means if the cross-examiner does start to introduce new evidence through this particular witness, it does pose somewhat of a problem because it's not completely within the flow of evidence. However, rather than require the witness to step down from the witness stand and wait hours, maybe days, maybe weeks before the defense puts their case on, to call this witness in the defense's case or in the whoever the opposition is, recall them in the prosecution's, a defense witness in the prosecution's case, the judge has some latitude to say, well, all right, I'll let you get into this issue on cross-examination, even though it's beyond the scope of direct, but solely to save time and not to inconvenience the witness. Needless to say, if this process confuses the issues, the judge is not going to allow it to happen and will force the cross-examiner to call this person in their own case. Subdivision B. The tradition in the federal courts and in numerous state courts has been to limit the scope of cross-examination to matters testified to on direct, plus matters bearing upon the credibility of the witness. And of course, many times they can't be anticipated at all insofar as direct examination is concerned. So that is subject to appropriate limitations by the trial court in terms of relevancy and the case law respecting proper cross-examination to challenge the credibility of a witness. Various reasons have been advanced to justify the rule of limited cross-examination. 1, a party vouches for his own witness, but only to the extent of matters elicited on direct. But we've gotten away from the concept of vouching for a witness, and in fact, Rule 607 rejects it. Usually, a party cannot ask his own witness leading questions unless they are prefatory questions that, for example, what is your name? Now, that assumes a fact that the person has a name. Well, okay, but we know that. And I will direct your attention to December 10th, 1951. What were you doing? Where were you and what were you doing on that date? Technically, that's a leading question of sorts. But what it does is serve to focus the testimony so we won't be wandering all over the place, just trying to get to some simple issues and to get the testimony jump-started. So that's permissible. This problem of direct examination on cross-examination is properly solved in terms of what's necessary for the proper development of the testimony rather than by a mechanistic formula similar to the vouching concept. A practice of limited cross-examination promotes orderly presentation of the case, but this latter reason has merit. The matter is essentially one of order of presentation, which the trial court always has authority to control. The provision of the second sentence that the judge may, in the interest of justice, limit inquiry into new matters on cross-examination is designed for those situations in which the result otherwise would be confusion, complication, or protraction of the case, not as a matter of rule, but as a demonstrable situation in the actual development of the particular case. Paragraph C of Federal Rule 611 provides that leading questions should not be used on direct examination except as necessary to develop the witness's testimony. Ordinarily, the court should allow leading questions, one, on cross-examination, and two, when a party calls a hostile witness, an adverse party, or a witness identified with an adverse party. The comment with respect to this paragraph states that the rule continues the traditional view that the suggestive powers of the leading question are, as a general proposition, undesirable. Within this tradition, however, numerous exceptions have achieved recognition. The witness who is hostile, unwilling, or biased, the child witness or the child with communication problems, the witness whose recollection is exhausted, and undisputed preliminary matters. An almost total unwillingness to reverse for infractions has been manifested by the appellate courts. The matter clearly falls within the area of control by the judge over the mode and order of interrogation and presentation, and accordingly is phrased in terms of suggestion rather than command. And the trial court's actions on appeal are going to be governed by an abuse of discretion standard, which is a high standard to reach in order to get a case reversed for this. Subdivision C2, the final sentence of FRE 611C, deals with categories of witnesses automatically regarded and treated as hostile. For example, Rule 43B of the Federal Rules of Civil Procedure has included only an adverse party or officer, director, or managing agent of a public or private corporation or of a partnership or association which is an adverse party. This limitation to virtually persons whose statements would stand as admissions is believed to be an unduly narrow concept of those who may satisfy, or safely rather, be regarded as hostile without any further demonstration. For example, in the Maryland casualty case, holds that despite the language of Rule 43B, that an insured fell within it, though not a party in an action under the Louisiana Direct Action Statute. The phrase of the rule, witness identified with an adverse party, is designated to enlarge the category of persons thus callable. So we're now looking in terms of a workable definition of a hostile witness as a witness who has been otherwise identified with the position of an adverse party. And I'll point this out because this is important. If on cross-examination, the cross-examiner wants to get into some collateral issues that are material, and the trial court says, no, that's beyond the scope of direct examination, that party has to wait. Either if it's the defendant cross-examining, has to wait to their own case to call this person as a witness, and if it's the prosecution or the plaintiff's witness, if it's the prosecution or the plaintiff who is cross-examining in the defendant's case in chief, they have to wait until rebuttal to call this witness. And this permits, in either situation, the party doing the cross-examination to call this other witness as an hostile adverse witness in either their defense case in chief or in the prosecution's rebuttal case. So this is a protection here, and that's basically why it's important to expand this definition. This rule also conforms to the tradition in making the use of leading questions on cross-examination a matter of right. The purpose of the qualification ordinarily is to furnish a basis for denying the use of leading questions when the cross-examination is cross-examination in form only and not in fact. as, for example, the cross-examination of a party by his own counsel after being called by the opponent. And this is, as it says, savoring more of the nature of redirect examination than anything else, or of an insured defendant, for example, who proves to be friendly to the plaintiff. Prior consistent statements. Section 22.14, rehabilitation, paragraph B. Prior consistent statements do not rehabilitate impeachment by prior inconsistent statements because the inconsistency remains. Now, what that means is if someone is cross-examined on the basis that they made a prior inconsistent statement, either in court or prior to the trial, they cannot automatically be confronted with prior consistent statements if they don't rehabilitate the position completely. And the reason for that is the prior consistent statements may only show that the person said something else, but they don't come in as substantive evidence because the inconsistency still remains. It's one person saying yes, it's another person saying no. And this particular individual saying yes and no. So that affects credibility. However, in some circumstances, a consistent statement may rehabilitate. And Federal Rule 801D1B, one of the hearsay rules, permits the admission of consistent statements to rebut an express or implied charge against the declarant. That's typically the witness on the witness stand who's been confronted with this inconsistent statement, of recent fabrication or improper influence or motive. In other words, one of the grounds for challenging this witness on cross-examination is that they either made up the later testimony for court or were improperly influenced. For example, if you don't change your testimony, things are going to happen to you that you won't like, or some other motive, such as they're now being paid by the other side to change their testimony, for example. And yes, this does happen, fortunately not very often. The rule makes these consistent statements substantive evidence rather than evidence merely affecting the credibility, because it directly rebuts this charge of recent fabrication or improper influence, because what's being offered is the fact that this person at an earlier time, prior to the opportunity to make up another statement, has made a statement that's consistent with what they delivered in court on the witness stand. And that out-of-court statement comes in as substantive evidence only if that very narrow challenge is presented on cross-examinations. Some courts, in fact, go so far to say that the statements are not admissible under Rule 801, but are nevertheless admissible for rehabilitation purposes in general rather than under an exception to the hearsay rule. And this again is a quote from the textbook Understanding Evidence that I spoke of a few minutes ago. And here's FRE 801D, statements that are not hearsay. All right? A statement that meets the following conditions is not hearsay. 1, a declaration or a declarant witness's prior statement. The declarant testifies and is subject to cross-examination about a prior statement, and the statement, A, is inconsistent with the declarant's testimony and was given under penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. And that can be very serious, because if someone's testifying inconsistent with an earlier statement in other testimony where they were sworn as a witness, that meets a statutory test for perjury. Testifying under oath to two different statements about the same subject matter that are inconsistent. That is the fundamental statutory definition of perjury. So that's a real problem, and it's almost a self-proving case. But that's a criminal issue that's not related here. That doesn't happen at the course of the trial. It happens later on if the state decides to prosecute the witness. B is consistent with the declarant's testimony and is offered to rebut an express or implied charge that the declarant recently fabricated it or acted from a recent improper influence or motive in so testifying, and we just talked about that, or identifies a person as someone the declarant perceived earlier. A matching statute from Florida, Section 9801, provides in subparagraph 2, again, a statement's not hearsay if the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is B, consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication, or one of identification of a person made after perceiving the person. And it can be readily seen that basically the Florida legislature adopted Federal Rule 801 with regard to how it addresses this particular issue. And the interesting thing about that is that since they both cover basically the same legal material, opinions in either federal or state courts can be used as persuasive authority in making an evidentiary ruling and in appellate proceedings to determine the propriety of either sustaining or overruling objections under these kinds of situations. That is one of the reasons why we have this very close uniformity between the federal and state rules of evidence. There are 6 methods that are generally used to impeach a witness. 1, by the introduction of other evidence that is contradictory to that given by the witness. 2, by proof of some defect of capacity in the witness to observe, recall, or relate the facts about which the witness has testified. Now, and before I get any further, number 1, the introduction of other evidence contradictory to that given by the witness. That doesn't necessarily mean that the witness is confronted by those inconsistent statements, but typically under rules, at least in some states, there is a requirement that before an inconsistent statement can be introduced against a witness, they have to be confronted with that statement and given an opportunity to explain it. And that is a very old common law rule called the rule in Queen Caroline's case in British litigation. 3, by evidence tending to show the bias, interest, or hostility of the witness under attack with respect to the parties or the issues, and of a kind or quality likely to color a witness's judgment or testimony. 4, by proof of prior inconsistent statements made by the witness, including statements the fair implication of which tend in a different direction than the witness has testified to under oath. 5, by proof of prior acts of the witness or of the failure to act or to speak when these fairly tend to contradict or qualify the witness's testimony. And 6, by disparagement of the general character of the witness under impeaching attack, limited to the proof of the witness's bad reputation for truth and veracity, or by proof of a prior conviction of a crime or for perjury. This is a limited rule with respect to the challenge of general character. And I want to go back for a moment. The paragraphs 4 and paragraphs 5 can be read in consideration with that paragraph 6 in terms of the kinds of things that a witness might have done prior to their testimony in the given instance, which gives rise to the applicability of this 6. And essentially what you're doing is challenging this witness about inconsistent statements that they have made in the past rather than a general bad reputation in the community. And that's what we're talking about. General character of the witness in their relevant community, the general reputation for truth and veracity. Rule 607, who may impeach a witness? Any party, including the party that called the witness, may attack a witness's credibility. It's rare when someone who is questioning their own witness challenges the witness's credibility. This most often happens when the witness gets on the witness stand and begins to testify in response to questions in a manner that's inconsistent with the information that this particular witness, or for the matter of the party in question, has given to their own attorney in the case prior to trial. Because the attorney in electing and the party in electing to call this witness is basing the use of this witness on what they have said in the past as to what they know, what they don't know, what they saw, heard, etc., and what they did or didn't do in a given situation, and have passed this information on to the party and their attorneys, and who are now relying on this witness to testify in this fashion in court. And if they're called, they can be challenged if they testify to something materially different, and I say materially different, from what they said prior to testifying. Essentially, what happens is the lawyer confronts them by saying, didn't you on April 10th tell me and my client in our office in an interview that X, Y, and Z occurred? That is inconsistent with what the witness is now testifying to. Now, what's happened there is it gives a witness an opportunity to say, oh, gosh, I forgot. You're absolutely right. That is what happened. That's my mistake. Now, it becomes a question of credibility of the witness, but at least the party who called them is not stuck with this witness's testimony. The notes of the Advisory Committee on Rules under this section says the traditional rule against impeaching one's own witness is abandoned as based on false premises. A party does not hold out his witness as worthy of belief, since he rarely has a free choice of selecting them, and this is the new interpretation of the concept. Denial of the right leaves the party at the mercy of the witness and the adversary. If the impeachment is by a prior statement, it is free from hearsay dangers and is excluded from the category of hearsay under Rule 801D1. The substantial inroads into the old rule made over the years by decisions, rules, and statutes are evidence of doubts as to the basic soundness and workability of the concept of vouchsafing for the truthfulness of a witness that you have called in your own case. Revised Rule 32A1 of the Federal Rules of Civil Procedure allows any party to impeach a witness by means of his deposition, and Rule 43B has allowed calling and impeachment of an adverse party or persons identified with him. So we are now freer to challenge these inconsistent statements on the part of the witness who is testifying by any means that allows for a proper revisit of the prior statements and informations. Florida Statute 9608 governs the same concept: who may impeach. Any party, including the party calling the witness, may attack the credibility of a witness by 1. Introducing statements of the witness which are inconsistent with the witness's present testimony. And that's the first example I gave you a few moments ago, where the lawyer is caught by surprise that the witness is not testifying consistent with what they previously said. 2, showing that the witness is biased. Attacking the character of the witness in accordance with 609 or 610. Showing a defect of capacity, ability, or opportunity in the witness to observe, remember, or recount the matters about which the witness testified proof by other witnesses that material facts are not as testified to by the witness being impeached. Now, I know you're going to look at this and say, gosh, that's pretty broad brush. Well, look at the scope of the rule. Who may impeach? It's not limited to impeaching your own witness. It's any party, including the party calling the witness, may attack the credibility of a witness by utilizing any or one or more of these approaches. And now let's talk for a few minutes about some cases that are decided under some of the relevant rules we have been discussing here. A party cannot bring evidence to confirm the character of a witness before the credit of that witness has been impeached. And by say before the credit, we mean the credibility. Before the credibility of that witness has been impeached, either upon a cross-examination or by the testimony of other witnesses. But if the character of a witness has been impeached, although upon cross-examination only, evidence on the other side may be given to support the character of the witness by general evidence of good conduct. One's character for truthfulness refers not to a suggestion of particular instances of honesty or dishonesty, but rather to one's general reputation in the community for telling the truth. And the court here says we find again that that is the defendant's credibility, was not attacked. Drury argues that a prior consistent statement may be used for rehabilitation when the statement has a probative force bearing on credibility, beyond merely showing repetition. This may well be true, but it does not change the fact that Federal Rules of Evidence 608 permits rehabilitative evidence only when a witness's reputation for truthfulness has actually been attacked. In Florida, they call it a bolstering rule, and that is not permitted. And this, of course, is under Rule 608A2. As we observed previously, the prosecution's questioning of the veracity of the accused's testimony and calling attention to inconsistencies therein does not constitute an attack on the accused's reputation for truthfulness, thereby permitting rehabilitative testimony. Again, Drury has pointed to nothing but a few cross-examination questions to support his claim that the prosecution attacked his character for truthfulness. Moreover, and perhaps more significant, prior consistent statements are treated as admissible non-hearsay only if they are offered to rebut a specific allegation of recent fabrication, not to rehabilitate credibility that's been generally called into question. The U.S. Supreme Court has said the rules do not accord this weighty non-hearsay status to all prior consistent statements. To the contrary, admissibility under the rules is confined to those statements offered to rebut a charge of recent fabrication or improper influence or motive. A district court is granted broad discretion in determining the admissibility of a prior consistent statement under FRE 801 D1B and will not be reversed absent a clear showing of abuse of discretion, which is the standard for all evidentiary rulings by trial courts. Of particular importance here, whether a witness had motive to fabricate when a prior consistent statement was made is a factual question properly decided by the district court, and the district court is the federal trial court, and subject to reversal only for a clear abuse of discretion. A prior consistent statement is admissible only if it was made before the alleged influence or motive to fabricate arose. And this is directly out of United States versus Drury, decided in 2005, and it is an 11th Circuit Court of Appeals federal opinion, and the 11th Circuit embraces the state of Florida. So it is binding on the federal courts in the state of Florida. Some Florida cases. The disposition testimony of a witness was admissible in civil proceedings under Florida Statute 90.608 for impeachment purposes where the prior statements of the adverse witness inconsistent with his in-court testimony. A defendant in his robbery trial could attack the credibility of the state's witness under 9608 by showing racial bias. Therefore, the trial court abused its discretion in limiting the cross-examination of the witness on that topic. When a witness is testifying on cross-examination, any answer to a non-material collateral matter is conclusive and cannot be impeached by normal means of impeachment, including contradictory testimony by another witness. And the test is whether the proposed testimony can be admitted into evidence for any purpose independent of the contradictions. Two types of evidence pass this test. One, facts relevant to a particular issue, and two, facts which discredit a witness by pointing out the witness's bias, corruption, or lack of competency. And Florida Statute 96082, as well as the Sixth Amendment to the United States Constitution, guarantee a defendant the right to a full and fair opportunity to cross-examine prosecution witnesses in order to show their bias or motive to be untruthful. If a witness is cross-examined concerning a collateral or irrelevant matter, the cross-examiner must take the answer, is bound by it, and may not subsequently impeach the witness by introducing extrinsic evidence to contradict the witness on that point. It is error to permit the state to call a witness to contradict collateral answers given during the state's cross-examination of another witness. So any contradictory statements and any effective cross-examination on collateral matters that arise during cross-examination is prohibited. It's only on material, direct matters under litigation. There is some dispute whether and under what circumstances impeachment of one's own witness is impermissible because of prejudice to the opposing party, particularly in criminal cases. And it's been widely held that a criminal prosecutor may not employ a prior inconsistent statement to impeach a witness as a mere subterfuge for the primary purpose of placing before the jury substantive evidence which is otherwise inadmissible. Application of the mere subterfuge or primary purpose doctrine focuses on the content of the witness's testimony as a whole. So the state, or for that matter a defendant, cannot get evidence that's otherwise relatively immaterial to the current proceeding in under the guise of challenging the witness on an inconsistent statement. And if the witness's testimony is useful to establish any fact of consequence significant in the contest of litigation, the witness may be impeached by means of a prior inconsistent statement as to any other matter testified to. The pivotal question is whether the party is calling a witness with the reasonable expectation that the witness will testify to something helpful to the party's case aside from the prior inconsistent statement. And this, of course, is the vouchsafe rule for a witness that an individual or attorney have called in their own case. Florida has aligned itself with the majority rule, generally permitting the impeachment of a party's own witness. Lastly, in addressing issues as to the impeachment of a party's own witness, trial judges must have broad discretion in determining whether the probative value of the evidence is substantially outweighed by the danger of unfair prejudice or confusion. And this, of course, is the state rule under Chapter 400 relating to excluding, under a court's discretion, evidence that is prejudicial to the other side unduly, or that it results in confusion, or we can extend the rule that it results in undue delay. and repetitive evidence. The state's questions to the defendant's expert witness about the expert's prior testimony for other defendants and other questions relating to his qualifications to discuss the defendant's mental health were permissible for impeachment purposes under 6081. And this does happen when, especially the prosecution, is confronted by hired defense experts. And basically, there's a huge cottage industry of these individuals out there who do nothing but offer their services for a fee to come in, take a look at a case for a defendant, and then testify against the state's experts with relative impunity. And some of these people are legitimate, and unfortunately there are a few who are not. That concludes the presentation on Module 9. Thank you for your attention.